Hi intellectuals, welcome to our channel. In today's video, we will learn about the concept of recognition of states through a question. Let's get started. The question is to find the main difference or differences between de facto and de jure recognition. There are 4 statements given and 4 options given. So before getting into the question, now let's have a brief discussion regarding the recognition or the concept of recognition of states. The term recognition literally means the formal acknowledgement of international personality of a newly born state by members of international community. So to put it in simple words, it is nothing but a process by which the existence and independent status of a newly born or emerged state is acknowledged by the members of the international community. There are some definitions. For example, Oppenheim has defined it as in recognizing a state as a member of international community, the existing states declare that in their opinion, the new state fulfills the conditions of statehood as required by international law. And the Institute of International Law has defined it as it is the free act by which one or more states acknowledge the existence of a definite territory of a human society politically organized independent of any other existing states and capable of observing obligations of international law by which they manifest through their intention to consider it a member of international community. Even Kelson too has defined it as, that is, he stated that a community to be recognized as an international person, it must fulfill the following conditions. And the conditions are, the community must be politically organized, it should have a control over definite territory, and this definite control should tend towards permanence, and the community thus constituted must be independent. So state to be recognized, it has to fulfill, that is, it has to primarily fulfill the essentials of a statehood. The essentials of a statehood is mentioned in the Article 1 of the Montevideo Convention. Article 1 of the Montevideo Convention provides that the state, as a person of international law, should possess the following qualifications. That is, it should have a permanent population, it should have a defined territory, there should be a government, and it should have the capacity to enter into relations with the other states. Now let's look into the theories of recognition. There are 2 main theories, the constitutive theory and the declarative theory. According to the constitutive theory, recognition alone creates statehood and clothes the recognized state with rights and duties under international law. It is a process by which a political community acquires international personality by becoming a member of the family of nations. So to put in simple words, only by recognition a state becomes a participant. Even Holland had supported this theory. He stated that a state cannot be said to have attained maturity unless it is stamped with the seal of recognition, which is indispensable to the full enjoyment of rights which it connotes. So to brief it up, until and unless a state is recognized, it cannot acquire rights under international law. Now coming to declaratory theory, this theory states that the statehood or authority of a new government exists even prior to recognition. So we could say that according to this theory, recognition is a mere formal acknowledgement or admission of an already established fact. Now let's see what are the various methods of recognition. So the recognition can happen in any of the following ways. That is, first, by conclusion of a treaty between the recognizing and the recognized state, or by admission into the United Nations organization or any other international conference and such other forums, or by sending, exchanging or receiving a diplomatic agent, or by formal appointment of its consul. So these are some of the methods of recognition. Coming to the kinds of recognition, there are 4 major classifications. That is, it can be either express or implied, it can be a conditional recognition, or it can be a collective recognition, or it can be de facto or de jure recognition. Now let's have a brief discussion on each of the classification. So first, express or implied recognition. So express recognition is accorded by some formal declaration or notification, and implied recognition is effected through acts which imply the intention to grant or accord recognition. So it is when the circumstances show that the state concerned has accepted or has been accepted as a member of the international community. The next, conditional recognition, that is, as the name itself connotes, it is a recognition which is accorded with certain conditions. But however, once recognition is accorded, it cannot be revoked. Therefore, failure to comply with the conditions does not annul the recognition. For example, in 1878, the Berlin Congress recognized the states of Bulgaria, Romania, Serbia, and Montenegro on condition that they would not impose any religious disabilities on any of their subjects. Collective recognition is effected through the medium of an international institution. It mainly aims to remove the anomaly of some states granting recognition and the others refusing to do so. But today, collective recognition is possible only by an international organization like the United Nations. Now, coming to the fourth one, that is the de facto and de jure recognition. So, among the all other modes, de facto and de jure are considered to be of more importance or of great importance. So the term de facto means by the fact. So de facto recognition is nothing but it is the recognition accorded to a new state which is independent but has not gained sufficient stability so as to be able to fulfill international obligations. So it is provisional and it could be withdrawn, that is the status given could be withdrawn in the event if the state is found incapable of fulfilling the international obligations. Whereas de jure is a Latin term which means lawful or legally or by right. So de jure recognition is granted when the state or government possesses all essential requirements of statehood and is capable of being a member of the international community. In other words, de jure recognition is accorded or granted if the state fulfills the test laid down by international law for effective participation in international community. And de jure is final and once it is granted, it cannot be withdrawn. Now let's see some important differences between de facto recognition and de jure recognition. De facto recognition is provisional and it could be withdrawn, whereas de jure recognition is permanent and it cannot be withdrawn. In the case of de facto recognition, diplomatic representatives are usually not exchanged, but in the case of de jure recognition, diplomatic representatives are exchanged. Similarly, the rules of state succession does not apply to de facto recognition, but it applies, or the rules of state succession applies to de jure recognition. A state which is accorded de facto recognition is not or is usually not entitled to get membership in the UN, but a state which is accorded the de jure recognition can or it is entitled to get membership in the United Nations. We could say that the distinction between the de facto and de jure is mainly political rather than legal. Now let us get back to the question. The question was to find the main difference between de facto and de jure recognition. So the first statement is de facto recognition may be withdrawn while de jure recognition is full and final. Yes, this statement is correct because we saw that de facto recognition is a status which is accorded provisionally or temporarily, so it could be withdrawn. But de jure recognition is of more of permanence or it has a permanent effect, and once it is granted, it cannot be revoked or it cannot be taken back. So the first statement is correct. Now coming to the second statement, it states that only de jure recognized states can represent the old states for the purposes of state succession. Yes, again it is true because even according to Fenwick and Locherpot, there are certain differences and they pointed out that in the case of succession, only the state which has been granted de jure recognition will be deemed to be the successor state. So hence this statement is also correct. Now, coming to the third statement, it mentions that in de jure recognition, formal diplomatic relations are established, while in case of de facto, they may not be entered into. Again, this statement is also correct because we saw that in the case of de facto recognition, usually diplomatic representatives may not be exchanged, but in the case of de jure recognition, diplomatic representatives are exchanged. So, thus, this statement is also correct. Coming to the fourth one, it states that former is legal and the latter is factual. So the former here they have denoted as de facto and the latter here is denoted to de jure. Again, it is a wrong statement because former, that is de facto, is a factual recognition and de jure is a legal recognition. That is, it is more of legal. So the fourth statement is not correct, or in other words, it is wrong. So with respect to the discussion made, we could conclude that option A, that is 1, 2 and 3, that is the correct option. So from today's discussion, I hope you all would have become clear regarding the basic concepts of state recognition. If you have any doubt, kindly put it in the comment section. Do follow the Courtroom Intellectuals for more updates. Thank you.